since like the 90s, there have been a number of inquiries into wrongful convictions and issues of trials that were pursued that shouldn't have been, that have all recommended that the Crown across Canada apply the same standard that we use in British Columbia. So in British Columbia, Crown will screen the charges and they'll say, is there a substantial likelihood of conviction? And if there's not, it's not just is there a likelihood or a possibility of conviction, a substantial likelihood of conviction, they don't go forward with it. So if all of Canada had that, we would avoid these types of cases coming to court. That's never changed, despite the fact that we see this time and again. What we did see after the Ghomeshi trial was significant overhaul to our sexual assault laws, but not ones that made it, less traumatizing for complainants. They just made sexual assault cases more complicated, where you had to have all these pretrial applications about whether you were going to cross-examine somebody on records, like their text messages and their emails and things like that. It ended up hugely burdening the justice system. It hasn't led to more convictions or making it easier for complainants. And so I think the only overhaul that maybe we'll see, and I don't think there's a political will for it, is finding a way to streamline a lot of these cases outside the traditional criminal justice system. For a lot of people, they're not after a finding of guilty. They're after, and I'm sorry, I realize
restorative justice, right?
Exactly. Yeah. And there's a huge call for that.